a pleasure to be with you this evening. And I think a particular pleasure because of the connection that I feel with UK-LFI. I think it was about 13 years ago that we hosted for the first time in Israel a conference. This was part of an initiative that we started in the legal department of the foreign ministry to try and engage in international legal outreach. And our hope was that, that groups of lawyers would start societies or groups that would be a resource in their countries. And UK-LFI, started by Jonathan Turner, David Lewis, and a group of remarkable lawyers, has really been since then a model of what you can achieve if you have a broad umbrella, if you're prepared to roll up your sleeves and do the work, if you don't insist on taking the credit for it. And it's really become a marvelous example to other societies around the world. So it's a pleasure to pay tribute to you with you and pleasure to be with you this evening. In a little preliminary discussion we had earlier, we thought what might be some useful framing remarks for our discussion this evening. And it seemed helpful maybe just to say a few words about the trends that have led to the international legal arena becoming such a problematic area of conflict for Israel. What are the trends that have actually led that to happen? And then maybe a word about what those mean for Israel and what those mean for the international institutions themselves. And for me personally, I think there was a very specific moment when the fact that something had changed dramatically in the legal arena came into sharp focus. And that was in 1998, where I had been participating in a series of preparatory conferences for the establishment of the International Criminal Court. And the head of our delegation was Judge Eli Natan, a senior judge, a great humanitarian, a Holocaust survivor, and an advocate of the court. He had been for many years. And at that conference where the Rome Statute was adopted, he stood up and made a speech explaining that because of the politicization of the court statute, he and Israel would not be able to join. And it was very sad, but it was also a mark that something fairly dramatic had happened in relation to international law, particularly when so many Israelis and Jews had 50 years earlier been amongst the earliest advocates of this International Criminal Tribunal. And I think it is worth just sketching out some, not all, but some of the trends that have led to that change in the international legal arena. I think one of them, if we're talking about international institutions, is an expansion of the area of political leverage in international organizations. It's always been the case that the political bodies of the United Nations, where there is sadly an automatic majority on any issue against Israel, have been very problematic for Israel. But by and large, until the 1970s, that kind of leverage was limited to the political organs of the international community, to the General Assembly. People will remember the nefarious vote Zionism is racism in the 1970s. What we saw happening in the decades that followed in the 1980s and the 1990s was an attempt to harness that automatic majority, that political leverage, and to use it to influence the human rights bodies of the United Nations, the Commission of Human Rights it was then, the other institutions in Geneva. That's when we saw them establishing unique agenda items only to target Israel. We saw more special sessions to condemn Israel than every other country in the world combined. And I suppose the culmination of that particular track was the Durban Conference, which was an attempt to actually coordinate and harness activity amongst human rights bodies. But what we've seen happening over the decades since then is an attempt to expand that circle of influence still further to legal and judicial organs of the international community. And we've seen it with the International Criminal Court, the International Court of Justice. We've seen it in individual countries with principles of universal jurisdiction and so on and so forth. Alongside that expansion, in a way, in parallel with it, we've seen something changing in international law, in the international arena, and that's the players. It used to be that you would describe international law as the law that governs relations between states. But what we've seen over recent decades is that states are not the only players on the stage. We've seen the addition of non-governmental organizations, international organizations and players and so on. When I'm teaching in the foreign ministry, there's a simple test that I try to use to explain this or to dramatize this. It's called the skyline test. Ask yourself, imagine a capital city in Europe in say 1820, and ask yourself what would have been the tallest buildings on the horizon. And almost certainly those would have been the steeples of the churches. They were the tallest buildings because the power was concentrated within the religious establishment. Move forward 100 years to 1920, ask yourself what would then have been the tallest buildings on the horizon. And those would probably have been the governmental buildings. They would have been the Big Ben or the Reichstag, because it was actually the state institutions that were the most powerful. But if you fast forward till today, till 2020, all of those buildings are dwarfed by multinational corporations, by international organizations, by non-governmental organizations. And what it means is we have something of a mismatch between the architecture of international law, which is focused on states, but the power that is diffused amongst many different types of organizations, many of which are doing wonderful work for non-governmental organizations, for example, do extraordinary work in relation to the environment, people with disabilities and so on. But they're also, sadly, quite easily hijacked because they're single-minded. They don't have to balance different interests and so on and so forth. And they can be very powerful tools in political campaigns. We've seen a number of other changes in international law. The subjects, not just the players, but the subjects of international law. It used to be that people would say that international law isn't proper law, because it doesn't have enforcement mechanisms. They used to say, a little bit like they used to say in relation to military law. The relationship between military law and law is like the relationship between military music and music. So there's not really a parallel between the two. International law was regarded as not really up to par because it didn't have enforcement mechanisms. That's something that's changed. And it's specifically changed, I think it's very, very sharply changed in relation to individuals that have increasingly become subjects of international law, which on the one hand has given them standing in front of various human rights tribunals, but on the other hand, it's made them subject to arrest warrants and criminal proceedings and so on and so forth. And I think one final thing that's probably worth mentioning is the speed with which international law changes. It used to be that international law was relatively cumbersome. It was very, very hard to change. If you wanted to try and demonstrate that there had been a change in state practice, this is something that actually take an awful lot of time. Actually, what we've seen is an attempt, again, partly by non-state actors, to speed up the process of international law changing. Not long ago, the International Committee of the Red Cross wrote what they called a manual of international military law. And that was supposed to be a list of what was customary international law, meaning what had become law by the practice of states. But when you read it, it was really taking an awful lot of shortcuts. It wasn't what states actually did. It was more what states said they would do, or what others said states ought to do, and so on and so forth. So I think if you take a step back and look at these trends, what you're seeing is that from having been a fairly cumbersome, state-centered, non-enforceable body of law, what's happened is that international legal arena has become far more flexible, far more speedy, far more non-state guided, with the potential to actually create enforceable results. And of course, if you are, let's say, a national liberation organization that happens to have a significant majority in international institutions, that makes it a very convenient tool for you to try and use as part of a political campaign. And that, in a sense, is a significant part of what the Palestinians have adopted as their strategy against Israel. And it's not a secret. It's actually, it's sort of public knowledge. President Abbas wrote what I thought was an extraordinarily frank article in the New York Times around the time that the Palestinians were campaigning for statehood in the United Nations. And he wrote this. He wrote, "Palestine's admission to the United Nations would pave the way for internationalization of the conflict as a legal matter not only a political one. It would also pave the way for us to pursue claims against Israel at the United Nations, human rights treaty bodies, and the International Court of Justice. Now, if you think about that for a moment, it's quite a remarkable statement. What you have President Abbas saying is not that we want to take Israel to international bodies so that we can become a state. He's saying, no, we want to become a state so that we can take Israel to international bodies. And I think that is, in a sense, an overarching kind of legal strategy. What does it mean in practice? In practice, it means that Israel is facing an array of legal challenges in a broad variety of international legal fora. On the international level, we have the formal courts. We have the International Court of Justice. We have the International Criminal Court. We have quasi-judicial tribunals, and we have a whole range of international meetings, human rights councils, and so on and so forth, conferences of the parties of the Geneva Conventions, and so on and so forth. And in parallel to that, we have a series of challenges that are taking place on the national level. On the criminal side, we have attempts to exercise the principle of universal jurisdiction. Again, here is an example of where you can see the journey that Israel has gone on. What's usually cited as the first example of the exercise of universal jurisdiction in history was by Israel, was the trial of Adolf Eichmann. But now, if you were to ask which is the country that is possibly the most concerned about the exercise of universal jurisdiction, it's Israel that's on the receiving end. We have in parallel to that a series of civil threats, civil actions, both against corporations and against individuals and so on. And then we have a range of boycotts and divestment initiatives and so on. And there's a lot to say about this, but I think one of the general comments to make about them is that they don't need to be successful in order to be effective. One of the things that is so difficult about them that, it is enough to have noise about a boycott campaign or a divestment campaign for the manager of a pension fund to think twice before investing in Israeli companies. A trial against an Israeli official traveling abroad doesn't have to be successful and almost certainly wouldn't be successful. But all you need is to have a senior Israeli official that has been held, detained on a journey abroad, and that has actually done something fairly significant, both in terms of Israel's image and also internally in relation to the likelihood that talented people will want to apply for senior positions in the army and so on and so forth. So what do these things actually mean for Israel in practice? So I think the first thing is that these initiatives take up an enormous amount of energy that could be used for better things. It's interesting, when I was in the UK and I would meet people who were campaigning for boycotts, I found a surprisingly effective thing to say to them was, if there's one natural resource that we don't have a shortage of in the Middle East, it's negative energy. Please don't export more negative energy to our region. We have enough of that. Think about positive things. Think about, ways that you can empower the Palestinians who support your values, the Israelis that you support your values, and so on. But that's something that is very demanding on governmental time, on non-governmental time. Secondly, I would say, the politicization of international institutions deprives Israel of genuine forum where it could engage and discuss some of the genuine dilemmas that it has. We don't think that we have the right answers to all the questions, but I think by and large we are asking the right questions. And it's frustrating that forums that in a sense should be helping you grapple with those. I mean, I once made what turned out to be something of a mistake. I was leading Israel's delegation to something that's called the Universal Periodic Review, which is a process that all the members of the Human Rights Council go through, and where you actually report on your human rights record. And we went through a period of taking this very seriously, and we engaged with human rights NGOs in Israel, and we spoke relatively frankly about the areas where we felt that we had fallen short of the mark as part of a genuine discussion. And then the floor opens up to questions. And in that case, the first question was from the representative of Yemen, who stood up and said, never in the history of humanity have human rights violations been committed to equal those of the Zionist entity. And you wonder why you bother. And I think that highlights another problem, which is that, if you're an international lawyer working for the government, in a sense, you're two-faced, you're Janus-faced. You spent a certain part of your time defending Israel to the international community, but you spend another part of your time being an advocate, a defendant of international law to your own government. And the more that these institutions are viewed as being part of a concerted campaign in Israel, the harder it is to make that case. And then I think we should mention the continuous dilemma that Israel faces, faced with an endless series of initiatives, tribunals, conventions, conferences, special sessions, and so on. Do we participate in this process or not? And that's a very difficult dilemma, because on the one hand, when, as is almost always the case, Israel feels that it has a case to make, that argues in favor of engagement. On the other hand, if you're talking about an initiative which is so clearly lopsided, is so clearly skewed, then your very participation is going to give some legitimacy to an initiative that really doesn't deserve it. I would say that by and large, Israel's default position is to participate. And I think Israel is at any given time cooperating with more international investigations than probably any other country that I can think of. But there are also a number of initiatives that are so clearly outside any reasonable realm of fairness that Israel doesn't cooperate with them. And I think a lot of countries, if they were in similar situations, wouldn't do that. So what are, and maybe just thinking about wrapping up and opening up for discussion, what might be some of the red lights, the warning lights that would actually help us identify these types of politicization in international tribunals? What are the sort of common themes that we see going across quite a lot of these initiatives? So I think, there are a number of questions that I like to ask, probably 4 questions that I like to ask when you're talking about an international legal initiative. So I think the first one is it really law? Because one of the things that we see is an awful lot that is presented as law actually isn't law by any reasonable standard. And to some extent, it's statements that are simply not legal. A General Assembly resolution, even a lot of Security Council resolutions, are not binding law, but they are cited as that. But I think beyond that, we have quite a concerted attempt to I don't know whether to create law or to misrepresent law in a way that is very pernicious and very, very damaging to Israel. I remember during one of our conflicts in Gaza, the presidency of the European Union, for example, called on Israel to halt its attacks because it said that activities that endanger civilians are contrary to international law. Now, if you think about that statement for a moment, it's a shocking misrepresentation of the law of armed conflict. There is no principle of international law, of the law of armed conflict, that says that where missiles are being launched at you from the heart of civilian areas, you cannot defend yourself. What it does say is that you have to have regard to principles of proportionality, principles of distinction, and so on and so forth. But international law is not a suicide pact that requires you to roll over and play dead. And that's a very, very dangerous misrepresentation. There was one time when the Secretary General, the previous Secretary General, made a reference to occupation being unlawful. And anybody that has studied international law will know that a situation of occupation is not in itself unlawful. There are things that you can do, there are things you can't do, but it's not a situation that is inherently unlawful. And there was a sort of remarkable statement that was made by the spokesperson of the Secretary General when this was pointed out to him, where he said, when the Secretary General said unlawful, he meant unlawful in the political and not the legal sense of the word. And that sort of obfuscation, I think it carries a price with it. I think we need to be careful about it. So the first question is it law? I think the second question is it lawful? Is the proceeding actually a lawful proceeding? And I think one of the significant red lights is when institutions play fast and loose with their own jurisdiction. I think respect for law also carries with it an obligation to have respect for the limits of the law. And frequently we will find that the initiatives that we are asking to be engaged with are fudging the issue. So the issue of Israel's security fence was brought to the International Court of Justice in The Hague. Now, the International Court of Justice in The Hague was a court that was established to basically arbitrate disputes between states with their consent. Here was a situation where Israel didn't consent, where the Palestinians weren't a state, and yet somehow or other, and we can talk about how, this issue became dragged to the court. I mean, the issue of statehood there for the Palestinians was particularly fudged because the court found that they were enough of a state to give the jurisdiction. But in its judgment, in a fairly shocking paragraph, they found that they weren't enough of a state for Israel to have a right of self-defense against attacks that were emerging from their territory. So I think those kinds of rewriting of the limits of your jurisdiction are another warning sign. Another thing that should go without saying, but unfortunately doesn't, not just is it law, is it lawful, is it universal? It should be absolutely clear that law, justice, selectively applied is justice denied. But unfortunately, that is, even though that seems obvious to us, that's not the case in the international community on all sorts of ways. I mean, if we think about the international tribunals, the International Criminal Court, the International Court of Justice, sometimes it's forgotten these are courts that Israel, however eminent its jurists might be, would never be able to have a judge on, because the appointment of judges is in practice allocated according to what's called equitable geographic distribution, which basically means according to the geographical working groups of the United Nations, which Israel is for many purposes excluded from. And finally, I would say, and for me, I think this is probably the most important question, is does it correspond to the reality? One of the things that we see in a lot of international proceedings is that they take place on a separate plane that seems to be very, very disconnected from the reality. A good way to see it is to take issues relating to Israel and to compare the way an international tribunal deals with them and say Israel's High Court of Justice, which frequently decides against the government. But if you were to take the security barrier, for example, it won't make generalistic comments in relation to massive swathes of security barrier without even considering security threats and so on. It will literally go meter by meter to try and think what is the appropriate balance to be met in any particular situation. But I think, unfortunately, there is, when it comes to our issues, there is some kind of magnetic force in our part of the world that sort of perverts a moral compass or a judicial compass. I remember one time I hosted a group of international jurists who were writing a report about Israel's conflict in Gaza. And I hosted them in my office in Jerusalem. And after about an hour or so of listening to their criticism, I said to them, look, you're an eminent group of international jurists. You've been to conflict situations all around the world. You've seen the challenges that we're facing here. Can you please tell me what, in your view, would be a proportionate and lawful response? And I was met with total silence. And finally, after a pause of I think it was several minutes, the head of the delegation said, that's an acontextual question. And so I said, what kind of context can I give you? But no amount of prodding would persuade him and his colleagues to roll up their sleeves and engage in the muddy business of asking what does it actually mean to implement these pristine principles in practice. I think that if we we try to draw to a close, I think there are one or two things that we can note. I think that one of the things that's very striking to me is that while initiatives of this sort against Israel are problematic for Israel, they very often are also warning lights about something dysfunctional that is going on in these institutions themselves. And if we needed any example of that, a report that recently came out, it's interesting to most people who care about Israel, if you mention the Goldstone report, they have a very particular report in mind that was problematic for Israel in relation to the conflict in Gaza. But more recently, Justice Goldstone was asked to chair a review panel looking at the International Criminal Court. And what became absolutely clear across 350 pages of this report is that alongside the challenges that it's facing for Israel, we are seeing a report that is riddled, or a court that is riddled with lack of professionalism, with actually internal bullying and unprofessionalism and unethical behavior and sexual impropriety and so on and so forth. And it seems to bring home that genuinely there is something is rotten in the state of Denmark, and it's not only the attitude to the state of Israel. So I think one of the final points that I would make, or maybe the final point that I would make before we open up for discussion, would be precisely this: that international law is not the problem for Israel. And if we think international law is the enemy or the problem, then we're doing ourselves a disservice and we're doing international law a disservice. What we should be troubled about is the misrepresentation, the distortion of international law. And by and large, our problem is not with international institutions. International institutions are critical. International law has a very important role to play in maintaining the peace and security of mankind. But the distortions of international law that frequently we find ourselves drawn into the expression of them, those are very, very problematic. And we, along with many other states, have an interest in trying to make sure that not just for Israel, but for the health of the institutions themselves, that they remain on track and that their integrity remains on board. Thank you very much.
Well, Daniel, thank you very much for that introduction. We've already had some questions into the Q&A, so please continue to add to those to our audience. Picking up perhaps first on this increasingly flexible state that you describe of international law, the blurring of the lines between international politics and international law, the use of political terminology as legal terminology that you've highlighted. How can we better distinguish between real international law and the misrepresentations or the abuse of international law against Israel when these red lights that you've picked out are all flashing? What is it, I suppose, first off, that Israel you think can be doing, but also interested lawyers that we have with us on this call, given, especially when we're looking at terminology like illegal occupation or more recently annexation, and the fraught debates around those, how do we highlight that they're often political as opposed to legal?
It's a great question. I think there's probably two things that come to mind as being critical, and neither of them are easy, I have to say. The first is we genuinely need to educate people. We need to educate people, that when often there's a sort of logic that acts against a deep understanding of what international law really means. Probably, one striking example is the word disproportionate. If a man in the street uses the word disproportionate, he's going to think of an equal number of people on one side of the divide or on the other side of the divide. And the notion that proportion here is not to do with counting bodies, particularly when you have a situation where you have a non-state actor, a terrorist organization that is trying to kill civilians on one side by hiding civilians on the other side. The proportion is in relation to the goal that you're trying to achieve, and that's something that needs to be explained. I think we have one asset this is the second point, that we don't use sufficiently. But it's also not easy. We are not the only people that care about these issues. And for example, in the UK, it was very rarely that I would meet somebody from the intelligence establishment or the security establishment that didn't see these views in a very similar way to Israel, or sometimes, in fact, thought that we might be being overly stringent. I remember I was an officer in the International Law Division of the Army, and my superior officer wrote an article about what are the measures that Israel takes before actually launching operations against terrorists within civilian areas. And the article described the series of measures that were taken, dropping warning leaflets, firing non-lethal weapons at the corner of a building, and so on and so forth. And before publishing the article, we sent it to a bunch of international legal advisors around the world. And the response that came from more than one of them was, please don't make it look like all of these steps that you're taking are mandated by international law, because we can't be sure that we would act in the same way in similar circumstances. So I think there are allies that we have there. You know, anybody that genuinely understands, you know, it's wonderful in the United Kingdom that, you know, it's a blessing that people have not had to face a serious, certainly existential security threat for generations. But it does make it harder for those people to understand what those threats call on us to do. And that's why I think if we can build those kinds of alliances, you know, far more powerful than an Israeli official speaking is somebody from the British establishment saying, we've faced similar threats, whether it was in Afghanistan, whether it was elsewhere, and so on and so forth. And we've actually applied similar principles, and so on and so forth. So I think it's a hard battle for us to fight alone, and we should be looking for allies who have an interest in clarifying these issues with us.
Now, moving to focus on a couple of these international institutions, the pre-trial chamber 1 of the International Criminal Court is still considering the jurisdictional question, and we're awaiting a response. We've had a question from an audience member asking you, what do you think will happen at the International Criminal Court vis-a-vis Israel?
So I won't surprise you, even though I'm no longer officially a member of government, I'm still involved in a number of discussions. So I'm not going to share the scenarios. I think one thing, and I've already hinted at it, I think one thing that will happen is that we're going to see the standing of the International Criminal Court drop still further. I think the International Criminal Court, which is genuinely an organization with potential. I would make a distinction here. I would say that Israel has, almost from a philosophical point of view, I think there is an issue with the notion of universal jurisdiction. It is by no means clear that any individual country should be able to put people from any other country on trial, even for very serious offenses. On the other hand, the basic logic of an international criminal court that says we shouldn't wait for the next atrocity to happen, but we should have an international institution that is there and ready in order to be able to try and ensure that victims get redress and so on and so forth, is something that we identify with. The problem is that the translation of that into practice has been very problematic. Not just in relation to Israel. If you think of the energy that has been invested, the resources that has been invested, the paucity of results, maybe 5 or 6 convictions altogether over all the years of its activity, and so on and so forth. And I think people don't like to talk about it because they like to talk about international institutions as almost sort of landing from heaven. But building an international institution is something that takes care and time. And you need to think very, very carefully how you build up its legitimacy. It was interesting, one of the Japanese representatives recently said, in relation to the case against Israel, he said, the court does not need more controversial cases. It needs more members. And this is a period of time where the court really should be thinking about how it bolsters its responsibility. And so I think that's something, you know, and I say genuinely with sadness, as much as we're on the aggravated side, that I think it would be a shame if the potential of an international criminal tribunal was lost because of this politicization.
Well, UKLFI was one of the organisations involved in making amicus submissions to the court. And there were, of course, many academics who made submissions on both sides of the debate. Daniel, what do you see as the role of academia in shaping the debate around international law and its treatment of Israel?
So I think one of the wonderful things about international law, and it's almost like a shot in the arm for UK-LFI, is that any individual academic or thoughtful person can actually play a role in shaping international law. You know, if you go to the statute of the International Court of Justice, is where people usually turn to try and find out what are the sources of international law. Up there with customary international law and treaties and so on and so forth, are the writings of learned jurists, you know, on issues of international law. And so I think it's tremendously important. I think these statements, I have to say, you know, I try to be as impartial as possible, but I read probably most of the submissions to the International Criminal Court on this issue. And to my mind, it was a slam dunk. That doesn't mean that the prosecutor or the pre-trial tribunal will decide in Israel's favor, but I thought the cases that were made, not just by UK-LFI, but a broad range of jurists were really extremely persuasive. And again, on the Palestinian side, you know, there are some problems in their argument. It's interesting, maybe this is unfair, but when the Al Jazeera Pali leaks came out, there were a number of documents in there that came from the Palestinian Negotiation Support Unit that were talking about the arguments that they were making before the International Criminal Court and highlighting internally the own weaknesses of their argument, which I thought was sort of fascinating. It's very rarely that you actually get this little insight into what is going on the other side. But so the first thing is, I think that there's a tremendous importance in raising your voice, writing these opinions, making these submissions. I would say not only in political arenas, one of the things that was so surprising to me in the United Kingdom was in how often in the Foreign Office, people would say to me, you know, we get a lot more letters of complaint from the Arab side than we do from the pro-Israeli side. And, you know, that is not the standard of judgment that you would expect a senior political official to have. But it turns out that the weight of the postbags has a certain value in itself. So I think those things are very important. The other thing is, I think we need to educate. We need to educate a new generation. I think it's wonderful to see, Natasha, to see you, talented young lawyers that are part of this operation and committed and so on, and to raise a generation of lawyers who are younger than you. And again, not to be necessarily just defense attorneys for the state of Israel. One of the things that I say to young people in particular, but not just young people, is, as I said, you know, Israel is not asking you to be a defense attorney. What we would like you to be is a character witness. We want people to know Israel, to know what it is that we're trying to do, to be party to our internal discussions as well. I think, by the way, that we have more credibility when we face outwards to make Israel's legal case, if we're also turning inwards and having a genuine discussion about what does it mean to properly implement international law principles in practice.
Just staying briefly with the ICC, because we've had a question from an American attendee asking if you can opine on the US asset freezing sanctions against ICC personnel. So these are economic sanctions that were imposed by the US Department of the Treasury Office for Foreign Assets Control, and they've penalized those supporting ICC investigations of the US and US allies, significantly here, including Israel. And several professors who are US nationals or residents have stopped providing support, the questioner says, to the ICC out of fear of being subjected to secondary sanctions under OFAC's program. So is this sort of proactive, offensive approach something that Israel should consider adopting?
So you might have noticed that there's a slight difference between the size and the resources available to the United States and the State of Israel. So not all of the things that are available to the United States necessarily appear in Israel's toolbox. I have to say, I personally do feel uncomfortable when the warfare becomes quite so explicit. It's not the most explicit. The fact is, we've had attempts, you know, American legislative initiatives would allow combat troops to charge into The Hague and arrest people and so on and so forth. So this, in a sense, is small fry by comparison. But I don't think it can be viewed in the abstract. And it's a part of what is likely to happen when you forget the limits of your jurisdiction. When you start playing fast and loose with your jurisdiction and with the goals of the court, then I think you're opening the door to all sorts of initiatives. And I'll go back to the comment that I was making before, which is that people who care about the court are, I think, rightly urging it to act with caution. It's one of the points that's made in the Goldstone report, is that at this stage, the court should not be overreaching even within its jurisdiction. This is the time for it to be engaging in more consensual, and sadly, there are enough consensual war crimes cases, serious crimes against humanity cases, that the court could be using in order to bolster its credibility during this period. And then this might be an issue that we could visit some way down the line.
Well, zooming out slightly, yesterday, of course, we had Israel and Bahrain signing a deal establishing formal ties in the wake of the Abraham Accords and the normalization with the UAE, and reports this afternoon that Sudan will follow with an agreement in a few days. To what extent, we've been asked, do you think the rapprochement between the UAE and Bahrain might change the situation towards Israel? And if I can ask, in addition, whether you think international law in the background has played any role in the movements towards peace we've had in the region of late?
So in relation to the first part of the question, I think we're seeing something wonderful, but what we are really seeing is something that was below the radar for many, many years, surfacing above the radar, rather than a dramatic sea change in attitude. I think I can say now that in the 1990s, I was one of the very first Israelis to travel to the Gulf to explore opening up relations. At that time, it was with Oman and Qatar. And we did something that for Israelis is very difficult, which is we kept our trip a secret. And yet the first morning we woke up in Muscat in Oman, the Muscat Times had a big headline, Israel's come to open up relations with Oman and so on. So they were straining at the leash. So I think what's happened here is that in a sense we're seeing a group of countries, hopefully a significant group of countries, that finally feel that with the new international environment, with the common threats of Iran, with the American position, that they can be far more above board. As far as the role that international law can play, first of all, I find myself, I look obviously with interest at the agreements that have been signed between Israel and the UAE, and a slightly different agreement now with Bahrain, and hopefully more on the way. And there's something extraordinarily moving about the way that a legal agreement is the architecture for those pieces. And I would point out too, for people who feel that there's not enough hope in the Middle East, one of the things that I sometimes point out that is the extraordinary resilience of our peace treaties with Jordan and Egypt. If you think about the changes that have happened in the region over the last decades, particularly the peace agreement with Egypt, where people weren't even sure that it would survive, from President Sadat to Mubarak, and now, to Sisi, Morsi and Sisi and so on. There's something, in a sense, what it says to me is it may be harder to make peace than we would like, but perhaps it's also harder to break peace once we've made it. And law creates that architecture. My experience from the negotiations with the Palestinians suggests to me that law can cut both ways. In the early stages of the negotiations, when you walked into the negotiating rooms, actually the lawyers on both sides of the divides were the ones who had a common language, a common skill set. And we were, to some degree, bridge builders. But when things turned sour a little bit, when there were allegations of non-implementation, then the lawyers, if you like, turned their faces outwards and became the most stringent, defenders of their side, attackers of the other side, and so on. And I think law really can cut both ways. One of the things that upsets me, I've read a lot of books, obviously, that have tried to analyze the Israeli-Palestinian conflict, both by Israelis and by Palestinians. And one of the things that gives me pause for thought is, I may be wrong, but my impression is that the ones that have been written by lawyers tend to adopt more extreme positions than the ones that are written by normal human beings. I think we need to be careful about what it is that we do with our legal tools. You know, I think when we have the will to make peace, law can be an extraordinary tool in building the scaffolding of that peace. And that's really what we have to aspire to. On the other hand, if we're not minded to be peace, then law can act as our shield or our weapon and so on. You know, and sometimes it strikes me that the famous, you know, biblical injunction, tzedek, tzedek tirdof, justice, justice should you pursue. And one of the classic interpretations is that, you know, we need to be just not only in the way we achieve things, the way that we use law, but in the goals that we set for ourselves. So I think that ultimately law is going to be a faithful servant, either for peace or not for peace, depending in which direction we point it.
Well, on that, looking to the Palestinians for a moment and gleaning from your decades of experience in terms of the negotiations directly between the Palestinians and Israel, is there a sense in which the focus on international law and the positions taken in the international community, where we've talked about the move from political to quasi-legal issues, might in fact be a wedge between the parties and be setting up positions within the Palestinian leadership on a misrepresentative legal basis that make it harder for them to come to the table?
So I think there's truth to that. I don't think international law is the main culprit. I think international organizations, and particularly the United Nations, do have a lot to answer for. I think what they've effectively created is a magnetic attraction for Palestinians away from the negotiating table. You know, if you are a Palestinian leader and you have a choice between going into a small and sweaty negotiating room and making unpopular compromises, or going to a podium in an international organization and spouting maximalist positions, you know, it is creating a dynamic that makes it hard to negotiate. On the other hand, I think that when we do sit down focused on peace building, then international law actually has tools for resolving issues. I think in all sorts of issues in our negotiations. And although we regard the Israeli-Palestinian negotiations as not having succeeded, and that's broadly true, along the way we did achieve all sorts of small successes and all sorts of mechanisms of cooperation that are still functioning. Quite often the way in which we actually achieved those agreements were through somewhat legalistic or using law as a resource for coming up with solutions to intractable issues.
We've had a question about the UN Human Rights Council, now the Human Rights Council, asking whether the Commission had been abolished. Of course, the Council in its current form has seen debates around Israel and alleged human rights violations around Agenda Item 7 and more recently the introduction of the blacklist. What challenges do you think those particular issues in that institution pose that perhaps might be different from institutions like the ICC and the ICJ?
So on the one hand, I would say that the Human Rights Council is less challenging because it is so widely recognized as an organization that has a body that has lost its direction. I don't think, and particularly if you just look at the states that were elected to the Human Rights Council, which are not the major human rights keeping states in the world and so on. So I think in that sense, reputationally, it's very low. But I think that these things don't stand in a vacuum. It's interesting, just in advance of this discussion, I looked through some old papers. Let me just see, and I came up with something that I'd forgotten. So here is, I wonder if we can go, it's in Hebrew, but you don't need to understand Hebrew in order to understand what this is. This was a part of a presentation that I made to the Israeli leadership around the time of the Goldstone report, the original Goldstone report. And it was showing what the recommendations of that report, what the implications, which forums it might actually play out in. And although it was confidential at the time, I think it's probably okay for me to share it with you now. And this is what the recommendations of that report actually looked like. And what you can see here is a single report that started from a resolution in the Human Rights Council, has prongs, if you like, that leads to the General Assembly, to the Security Council, to the ICC, to the ICJ, the national institutions, and so on and so forth. And what you're seeing here is the creation of, I mean, again, what I could have mentioned earlier, you know, one of the red lights that I highlighted when we see the politicization of international organizations is whether what they're relying on is actually law. And you see a sort of surreal ping pong where one rapporteur of the Human Rights Council will effectively make something up and write it in a report, and then it'll be quoted by another reporter and footnoted, and somehow or other it will snowball its way into a reference in a General Assembly resolution, and so on and so forth. So I don't think these things operate in silos. Unfortunately, there is some kind of network. And I think there's probably a lesson here for organizations like UKLFI, which is that these types of activity are fairly flexible and fairly broad tent. And that means that in responding to them, we also need to have that same sort of agility. And we also need to be relatively broad tent. You know, sometimes we like to check people's DNA before we'll let them into our club and agree to do anything with them. And I think in a campaign of this nature, if somebody is pointing in the right direction and concerned about the same things, we should find a way in order to partner so that we can be effective.
We've talked about the UN Human Rights Council, the International Criminal Court, looking briefly to the International Court of Justice.
Sure.
Do we potentially see an additional set of challenges in the context of the case brought by the Palestinian Authority against the United States for the US moving its embassy to Jerusalem? That is an intense legal debate about the status of Israel's capital potentially being conducted without Israel being a party to the proceedings. What do you make of that?
It's obviously a cause for concern, but I have to say, if I had to list the causes of concern that we have on the international legal plane, I'm not sure how high that one would be, partly because I think even for a court that is open to a certain degree of grandstanding, this will be a very, very hard case to support. I haven't studied it deeply, but first of all, I don't see it's a court. It's a proceeding that's effectively based, a claim that's based on the Vienna Convention of Diplomatic Relations, which doesn't really give standing to the Palestinians to actually try and launch this kind of conflict. And more problematically, the ICJ has a principle called the monetary gold principle, which is the most relevantly involved states have to be party to the proceedings. In that case, it's hard to imagine how Israel, this being the American embassy to Israel, would actually could be sidelined from it, and so on and so forth. So maybe there's more there than meets the eye, but from the little that I've seen, I think in tangible terms, I think this initiative is one that is probably not likely to go very far. I think generally, all of the other concerns that we've said about the harnessing of international arenas for part of a political campaign, you know, they apply here as well.
We've had a couple of questions about the ways to conduct conversations with Israel on highly charged issues, or about Israel on highly charged issues. And in particular, a question from a student who asks, what would you suggest is the best way to respond to someone who volleys off claims like the occupation is illegal under international law, or Israel routinely persecutes Palestinians and restricts their legal human rights?
So
easy one for you there.
Sure, no problem. I've got the answer that you just need to give. Actually, I do have an answer. I'll give it in a moment. But the first thing that I say, I think is very important, is that you should not waste your time having conversations with people who are not open to having a conversation. If somebody is effectively programmed, or as is sometimes the case, maybe even receiving a salary in order to spout a particular position in a particular context, then I really don't think it is worth you using your energy and effort and emotional resources in order to engage in that campaign. If, on the other hand, you come across somebody who genuinely has grown up with very, very different, sometimes I would visit campuses where the whether the frictions between pro-Israel supporters and pro-Palestinian supporters were so acute. And what I would suggest that people do in those situations, if they were open to it, was to sit down and on any particular issue, each side to try and write a half-page summary of what they thought the other side's position was. And it was a remarkable exercise that people suddenly realized that they had these preconceptions and didn't understand, didn't appreciate each other's position. And I would say one other thing. I would say, the first thing, if it's somebody that has a specific accusation, it's very difficult. Somebody that says Israel is always, it's really very, very hard to respond to a blanket allegation like that. Come up with a specific case that is concerned with you, and we'll look into it. And I would say, I unfortunately didn't have this luxury, but anybody that is a friend of Israel has what is, to my mind, a very, very good answer that they can give in relation to any specific allegation against Israel. And that is to say, I don't know the details of the case, but I will find out and I'll get back to you. And I think showing that degree of care, and thankfully there are, and I can volunteer the services of the embassy in London now without, without regard to their workload and so on. But the final thing that I would add in this context is that I really think, and particularly on campuses, we have to break out of this notion that Israeli-Palestinian relations are a zero-sum game. That if you are pro-Israeli, you have to be anti-Palestinian and so on and so forth. Genuinely, the vast majority of Israelis are true supporters of the idea of a flourishing, prosperous Palestinian society next door. And the conflict is not between the aspirations of those sides. Far more it's internal. I once visited a campus in the United Kingdom where there was a demonstration against me, and I had my laptop with me. And I said to the demonstrators, I want to show you a very brief clip. And I showed a very brief, maybe a few seconds long film clip that was filmed in Gaza. And some of you may have seen this. On this clip, you see a Hamas soldier with a weapon on his back who is stepping out from between some buildings. He wants to cross a road, but he knows that the moment he steps out from between the buildings, he's going to be exposed. And so what you see him doing in this film clip is grabbing hold of a Palestinian kid who may be 6 or 7 years old and holding him in front of him, literally as a human shield, while he crosses the road until he gets to the other side, casts him aside and goes back between the buildings. And I said to the demonstrators, I don't have a problem with you being pro-Palestinian supporters. Palestinians need supporters around the world. But I want to know which of those two Palestinians you're supporting. Are you supporting that Hamas terrorist? Are you supporting that kid that's going to grow up incapable of imagining a future different from the one that he's grown up in? And just to go back maybe for a moment, I think law in its best incarnation has to be a tool to help us climb out of those preconception positions that we find ourselves in. It has to be something that aspires to universality, that aspires to peace and justice and so on and so forth. And to the extent that we're doing that, then we're advancing both the causes of justice and the cause of peace.
Well, Daniel, with the final response, you've also answered the question of what individuals can be doing to address these misrepresentations, grappling with the individual examples. There's also a wealth of resources on the on the UK Lawyers for Israel website that is constantly being updated, as of course the international legal situation is constantly developing and new allegations seem to be emerging all of the time. So those resources can certainly assist. Thank you so much, Daniel Taub, for taking the time and providing us with this incredible insight into your experiences of Israel in the international legal arena. And thank you so much to our audience. Please consider a donation to UK LFI if you have found this webinar valuable to enable us to continue that important work and providing that support and grappling both nationally and internationally with the lawfare that continues to target the state of Israel. Daniel Taub, It's been an absolute pleasure. Thank you for
It's a pleasure. Thank you so much, Natasha. Thank you all.